Good evening, this is Rahul Reddy. We had some technical difficulties. Today we're going to discuss about the class action lawsuit filed on behalf of H4 and L2 holders because of the delay in the H4 and L2 extensions, and also on the H4 EADs and L2 EADs extensions and also initial filings. We're going to also discuss about the final action date movements for the EB2 and EB3. They're going to be advanced more aggressively. We're expecting the filing dates, which is January of 2015 up to be the final action dates by September. That's according to the State Department. We're also going to discuss about the 485 application or adjustment of status approvals without the interview, which is a good news. And Emily is going to discuss about the Republican immigration plan. Emily, on the class action suit, why do we have to file? I mean, why did people file the H4 and the L2 EADs class action suit?
Right. As you likely know, we've been fighting these delays in H4 EADs for almost 2 years now, ever since the biometrics requirement came out. And as part of those different lawsuits that we filed, we were able to gather a lot of data and background information about how USCIS is processing these. And that has led us to partner with the American Immigration Lawyers Association, along with the firm of Wasden and Banias, in order to file a class action lawsuit to once and for all end this unreasonable delay. And so that was filed last night. The next step is considering whether to file a preliminary injunction. And that depends really on how USCIS or DHS and their attorneys respond to this lawsuit. The idea is to bring them to the table to negotiate some kind of solution and resolution for people whose applications literally take 12 minutes to approve, yet they're taking 12 months before they ever get processed. And the problem with these biometrics, we're showing in the lawsuit that there's no rhyme or reason at all. We have several people all in one city who filed over several months period of time. The people that filed first, did they get their biometrics first? No. People that filed later got their biometrics. And it's just so hit or miss that we've been able to point to all of those data points in the class action lawsuits. I think it's a very strong case, so we're hopeful that we'll get some resolution within 30 to 60 days, depending on how USCIS responds. Ultimately, we want the biometrics eliminated, or we want them to use the biometrics that you gave at the consulate and that you gave at the port of entry. Why do we need to go through this process again? And we have a lot of data in that lawsuit that shows that USCIS does in fact have the capability to do that, even though all this time they've been claiming they didn't. So we're very hopeful with this, and we hope to solve this problem for people once and for all.
Emily, on the final action dates, so we have the State Department's video last week did give us very, 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 very good information. They have said that the EB2 and EB3 is going to advance very fast. We may be expecting to see the final action dates to move maybe up to all the way to January of 2015 by September of 2021. Now, a lot of people had dilemmas with regards to will the USCIS will be able to adjudicate the extra 100,000 green cards on top of the 140,000 green cards that the employment-based visa people are allocated. According to the stats by the State Department, only 9,000 out of the 140,000 green cards were not being used in the year of 2020, starting from October 1st of 2019 to September 30th of 2020. But we have had some changes right now. It was the previous administration, which we were definitely not comfortable with the previous administration. They were just anti-immigrants. They used to feel that immigrants are undesirable people. But however, the administration has changed, and we have seen a lot of 485 approvals recently where the priority date has been current. We have seen that when the EB3 movement have already occurred. We have seen some cases filed in October of 2020 got their green card approved. I mean, some of our legal assistants were receiving these approvals. Rahul, what's going on? Can we send this green card approval to the client? Is it something that we're is that something bad? Then we have to go and check everything, make sure the final action date is current. And then we said, oh, yeah, go and tell the client right now that green card is approved. I personally like to call the people when I get it. Hey, your green card is approved. That's the happiest day. I remember when I got my green card approval, I straight went to Red Lobster and ate my Red Lobster at that time. I really want to enjoy the day when I get my green card. So it is very, very surprising, the people who got their adjustment of status filed in October got it. But there are a couple of conditions for the USCIS to approve your green card, guys. There are certain conditions that they cannot do it. One, your final action date has to be current. Now, which we are expecting a lot of movement to be coming. So I want you guys to prepare for it. It is not in your hands. The second thing is that your I-140, the underlying I-140, if you have a downgrade application pending, and if the I-140 is pending, technically speaking about, the USCIS cannot give you the green card. So I urge all the people whose adjustment of status is pending to file the premium processing immediately. We discussed about the premium processing in the last week video. If you want to watch it, you can watch it. But please go ahead and do the premium processing if you have not already done, and they are adjudicating the I-140 approval. The third thing is that the biometrics has to happen. And we have noticed that the cases that we filed in October last week, we are receiving the biometrics. They're scheduled anywhere between April 1st week to about April 3rd week right now. So we're expecting all the people who filed in October, most probably their biometrics should be done soon. But as I was stating at first, that the final action dates has to be current. Second, the I-140 has to be approved. The biometrics has to happen. The fourth condition is that if by any chance you didn't file the medicals along with the 485, you can still do so. You don't have to wait for the RFE. What you can do is that it's called interfiling. You use the interfiling and you file the medicals even if there is no RFE issued. Now there is a chance they may ignore the interfiling and tell you to do it again. But if I were you, remember, as soon as I got the green card, the first thing I did is I went to Red Lobster. I ate a big lobster. I mean, I did not even look at the bill at that time, how much I paid. So I know how happy you will be, and I think so you won't mind paying extra money for the medical. I know you guys, so you won't mind. So I will do the interfiling, and then if the RFA comes in, I will do it again if I have to. But I don't want to have the officer take a second looking at it. If these four conditions are met, the officer could give the green card without any interview. If any of these four conditions do not meet, they cannot give the green. One, the final action date has to be current. Second, the I-140 has to be approved. Third, the biometrics have to happen. Fourth, the medical has to be there. Now, two of them, medical and I-140 approval, are in your hands. The biometrics are not in your hands, and the final action dates are not in your hand. So these two things, take care of it right now. When the officer opens the file, they can give you the green card immediately if all these four conditions are met. There is a lot of pressure on the USCIS officials right now to use up the numbers. They may have some backlashes within the USCIS because this administration do not want to waste the green cards. So all of you guys who have filed adjustment of status, be alert and keep coming to our YouTube. We'll keep on updating it and make sure that at least all these four conditions as much as possible are met, and be prepared to get the green card as soon as possible. Anything else, Emily, that you want to add?
All right. I think also we want to discuss the...
Oh, Emily, I want to add one more thing, though. We forgot to tell another good news for them. Next year, that is October 1st of 2021, there's going to be extra 135,000 green cards that will be coming to the employment-based. Remember, when approximately around 100,000 green cards came in, the priority date moved from 2009 all the way to December 31st of 2014. Now, the State Department is telling the final action dates by September are going to move maybe up to December of 2014. What will happen, Emily, if 135,000 green cards will be added to the entire thing?
Yeah, those dates are going to jump again. So October is going to be just like it was last year. We may see another 2 to 4 year jump in the filing dates in October of this year. So be prepared for it.
Can you guess it though? Last time you estimated the priority date will move to 2013. I estimated at 2011. We both were wrong. Can you estimate this time though?
I'm going to guess 2016.
Well, I'm going to. How would it be? It's already 2014 December though.
Well, I think more and more people, you're adding more. We know from the data that every single year more labor certifications are approved. So we've got a smaller pool of people in that 4-year span that it jumped, and then the pool of people keeps getting bigger every year after that. Of course, we don't know how many of those labor certifications are for people who already had another labor certification and changed jobs and needed to get the new I-140. No one has that data. So that's my concern, is we may not see as big of a jump because there are more people in that time block with priority dates waiting.
She has been wrong 100+ times in estimating the priority date. I hope she'll be wrong again. I'm going with 2018 priority date. That's my guess. We may be wrong, guys, but what are the things that you guys need to be aware of is that if you're contemplating of changing the jobs, if I were you, I would not. Remember, because the new labor certification process is taking much longer time, you may miss the boat if you leave the job. So you may want to be very careful if you are contemplating in moving into a new job. If your company which you are working did not already file a labor certification I-140, I want you to work persistently in getting the labor and I-140 filed. These are the steps that you can take. And be watchful. The movements have been very, very erratic in the recent months though, and are expected to be. So be on the watch, be on the alert on these things, and take the necessary actions. For example, if you are already in adjustment of status, you want to get an I-140 approval. So if you have not done the medical, you should get the medical done. If you have not updated any of the change in address, you should update the change in address. Anything else, Emily?
All right. Last, we wanted to give you an update on legislation. Last week the House did pass 2 immigration bills. One for the Dream and Promise Act, which is geared towards dreamers, but does include a very important provision for aging out kids of H4 and of H1B and L1 and E visa holders. So that is a great benefit to have. And then there was a farm worker immigration bill as well. Those are not bipartisan, meaning it was only Democrats that passed that. Nothing has happened in the Senate yet. And now we hear the Republicans are trying to unveil their framework for immigration reform. And so we got a little bit of a taste of that. Nothing there at all for employment-based, no elimination of the 7% cap, nothing for aging out kids. It's all border security, mandatory e-verify, having the dreamers serve a long period of having some sort of temporary status, and then later the opportunity to get a green card and citizenship, and that's it. So we'll have to wait and see, number one, when this bill actually gets introduced, how much sway they have, how many co-sponsors there are, whether it starts in the Senate, whether this is in the House. And then we just really have to see what the Senate's going to do and if they're going to try to compromise between all of these different bills. Still haven't actually taken up Biden's immigration plan. So we have a lot of things that could happen over the next few months on immigration reform, but the Republican framework leaves a lot to be desired for employment-based.
A lot of questions on the 485 application. One of the gentlemen who suggested that our audio was not working before. Thank you very much. We appreciate. Sorry for what happened. We try to correct it as fast as possible. To answer his question, how do we interfile the medical? Good question. If you have not already filed it, we estimated the priority dates a little bit differently. So if you have not already filed it, what I want you guys to do is that I want you to file the interfiling. The word that you used is that INTER, interfiling, FILING. That's the word you use, and you will use the A number, you will use the file number for the adjustment of status. You're going to attach the medical, and then you will send it to them. What is this interfiling is that we are telling the officer, look, there is an additional document that we did not have it before, we have it. Please insert that in the file. That does mean in the interfiling. So if we write a long letter explaining to that, some officer has to read it and he has to use the word interfiling. Well, if you use the same word, then interfiling, this guy knows what he's doing. I'm going to just stick this one in the adjustment of status application. That's the word you need to use, and you need to send it to the place where you are supposed to file the adjustment of status. And once you do that, I mean, they will stick that medical into your file, and you'll be in a good shape when the things come in order.
All right, time for some questions. Arun from Facebook has a green card EAD pending and wants to know if his spouse should file her H4 EAD. Does that have any kind of negative effect on the green card EAD? So it's your choice. Now, the H4 EAD is not free in terms of filing fees. The GC EAD is. There's no filing fee to file the green card EAD or renew it again and again. Now, why would you use the H4 EAD over the green card EAD? That's only if there's something particular in your situation that your wife needs to remain in H4 status and not get married to the green card process. So for example, if you have kids who may be aging out and need to be able to switch to F1, if she were to drop off the H4 status, and you drop off your H1 status, that could impact an aging out child. Or if you're not married, in your case you are married, but some of the reasons why we tell you not to get married to your adjustment of status is if you as the main applicant are not married and may get married to someone who is not a U.S. citizen, you need to be able to get them here on H1B. And also, if your I-140 is not yet approved, you may want to consider remaining in your H1 and H4 status until that happens. But if your I-140 is approved and those other issues, there's no red flags in your 485, you do have the option of forgoing the H1 and H4 status using the green card EAD instead.
A lot of questions are coming with regard to the 485 filing dates and final action dates, and where did we get the information that the filing dates are going to move? First, let me answer that. The State Department has mentioned that it is expected that the final action dates will move all the way to the filing dates. You know the filing dates that happened in September of 2020. You can look into those things. You're well educated if you're on audiences of Radio NMNPC, if you're watching, what a filing date is and what a final action date is. So you will be able to see what you can expect by September of 2021. Now this is not what Emily has been guessing, which she goes wrong, and Rahul has been guessing, which I go wrong most of the times. But this is what the State Department officially has given a statement, that the dates are going to up to, he didn't say that it will, there is a good chance that it will move. He has a good estimate of the number of applications filed compared to, the USCIS has not been releasing that information, but they have to release that information to the State Department. So they have a good idea of the number of applications filed. So that's the reason why we're expecting the final action dates to move very, very fast. Now, where did we get the information that the filing dates are going to move starting from October of 2021? You're right, the audiences have, you're right, it was not explicitly stated by the State Department. But think of this thing, if the final action dates moves very forward until September of 2021, in October of 2021 though, that's a new year. New year for the immigration starts on October 1st. So for the fiscal year of 2022, they have to consume 140,000 plus 135,000 green cards. That will be approximately 275,000 green cards have to begin. Now then comes the question, well, what does it say? Why does Indians will get more? Here is the thing. Most of the dates are current for everybody. There's nobody in line to get the green card. The only people that are in line to get the green card are Indian nationals, to some extent some Chinese nationals. Even if there is somebody else in the line, the Indian nationals are, I would say, not way behind or way forward, how you take it, but their priority date is way, way ahead of compared to the Chinese nationals and other nationals. So when the dates move, these extra 135,000 green cards are being thrown. When there is nobody waiting, they will have to give it to Indians. Out of these 135,000, I'm expecting anywhere between 100,000 to 120,000 extra will be going only to the Indian nationals. So that's a good number. Typically, Indian nationals will get anywhere between 20 to 30,000, depending on how many non-available, how many other countries are not using, anywhere, maybe 40,000 at a maximum. But in the year of 2021, starting from October of 2020, and in 2022, our numbers will be swelled so much. Indians will get more than 100,000 green cards this year. Indians will get more than 100,000 green card next year, compared to approximately 20,000 every year. That's 5 to 6 times more than what they were been getting. So that's a good moment we are expecting for Indian nationals to move. That is our estimate. Hopefully we're right. And last time when we both estimated the priority dates, the State Department surprised us. I estimated to be 2011. Emily estimated to be 2013. Guess what? It went all the way to January of 2015. She was wrong. I was wrong. And hopefully next year we're going to be wrong and State Department is going to do much better.
Suresh from Facebook wants to know, when an adjustment of status is downgraded to EB3 and the applicant moved to a different company, can the new company upgrade to EB2 if those dates are current? No, the only way to upgrade to EB2 is if the new employer files a new labor certification and a new I-140 in the EB2 category. You can do that only with the old employer that has the original EB2 approval. Pratyusha from Facebook also wants to know, what is the situation of consulates in India? Do we see them going back to normal functioning anytime this year? They are still very much not operating normally. They're only taking pretty much emergency appointments still. They have expanded the Dropbox option, which does leave more appointments open for other people, but I'm going to say at least fall before they get anywhere near being back to normal, because we have to get this virus under control.
Archie Americas I have an old EB3 approval with a priority date of May 2013. My new employer is processing the labor and I-140. Should I contact the old employer to file an I-140 and I-485 concurrently? It depends on what stage your existing labor and I-140 application is pending with your current company. I'm also assuming that your previous company has not withdrawn the I-140 before January 17th of 2017 and before 180 days after I-140 is approved. If that's the case, you can port the date into the new employer. I've also seen a lot of other people asking questions. What do I do? Do I go back to the old employer? Do I stick with the new employer? If you're, and one guy said his labor certification has been filed in December of 2020. What does he do? I mean, should he go back? If the labor certification has been filed in December of 2020, I may stick with the current employer instead of going to the old employer. As of today, 8 hours ago or 6 hours ago, every day I'm checking my labor certification approvals. What date? It's because everybody is asking the question. We do conduct a daily Zoom conference call. So if you guys want to, you can check at RN Law Group and go to conference call. We do have a Zoom conference call that we conduct every week. So I get to ask question, what is the date that people are getting the labor certification approval? I check every day. Right now, today, about 6 or 7 hours ago when I checked it, we got 2 approvals today. 2 of them are dated August 7th of 2020 is the date of the application we filed with the Department of Labor. So if yours is in December, you're 4 months behind. By the time you go join the old employer, maybe this labor certification might be approved, most probably. So I may not be inclined towards going back and joining the old employer. If you guys have some dilemmas, sometimes these are judgmental calls. These are not legal matters. You guys are getting so much education, because of the YouTube and other things, and thanks for listening to us. You're getting, so some of the legal knowledges you definitely have, but certain times you have to make a judgment call. Oh, what is this? When do I go? Do I go to the old employer? There are pluses and minuses for each of those things. You need to evaluate those things. and take a judgment call in those things. And sometimes you may want to consult a lawyer to see what does he think he should do. Especially go with an independent lawyer. Don't try to go with your company lawyer, because your company lawyer is biased towards the company. We represent companies, so we favor our companies. There's nothing wrong with it. So we advise, when you take these judgment call things, try to go to outside lawyers to get a better judgment call.
Somasri from Facebook wants to know, how long is the perm processing currently taking? As Rahul said, we're starting to see approvals for cases that were filed in August of 2020, but you do need to be aware of the processing that it takes just to get the case filed, which has also drastically increased. So the first step is typically submitting the prevailing wage request. Those are taking 5 months plus to receive. Now, in the past, we could often start the advertisement or recruitment process while we were waiting for that prevailing wage. Nowadays, that's very risky, because you might not even get your prevailing wage back in time and your ads are going to expire. So that is causing the process of getting the prevailing wage and then doing the advertisements. It might take a year to go through all of that before you can actually file the perm, and then they're taking another August through March, however many months that is, 6, 7, 8 months to process. So you really should plan on starting that at least 2 years before you're going to hit your 6-year limit, to ensure you have enough time to get through that long prevailing wage, all of the recruitment, file, long processing time, get the approval, and then file the I-140. And at some point, I-140 premium processing may be suspended. So you want to work in that time to make sure that you're not stuck at the last minute and maxing out of your H1B time and not able to get the I-140 approved.
This question from Jani is coming. I'm working with Indian-based company. My priority date is EB2 2014. My company did not downgrade. Is it a good idea to change the company? That's a tough question. I hate your company. And guess what? Your company hates you. They don't like you. I mean, look at it. A lot of companies did the downgrade. Why did your company do the downgrade? I know the lame excuses these companies have made. We've been telling from long before, downgrade is not a problem. Everybody said downgrade is a problem. We need to amend the application. It's not a new application. Old application is going to dead. That all turned out to be not true. A lot of companies have filed the downgrade application. I fear, Mr. Jain, that when the priority date becomes current, would they really file the adjustment of status? Could they make another excuse? Oh, I'm in the process of changing the law firm, so I don't want to file a 485. I don't know. So when any company that has not downgraded, though, I don't personally trust those companies at all. And they have given some legal reasonings which are completely, utterly false. The only downgrade applications where I feel problematic is definitely the national interest waiver. There is one doubtful thing, especially for the physical therapists who filed under EB2. That is a little bit doubtful, those things. But other than that, everybody can do the downgrade. I don't see a problem with that. So if the company has not filed the downgrade application, I don't know whether I should trust the company when the time comes whether they will file the adjustment of status. That is my expectation. So it's your judgment call to do.
Indu from Facebook said there are staffing agencies openly advertising on Facebook and LinkedIn asking students to file multiple H1B registrations in the cap to increase the odds in the lottery. What is our advice? We've said from the beginning, do not file multiple H1Bs, even if it's with different companies. It is very risky, not to the individual who's doing this, because USCIS does track all of that. This registration process is completely electronic. That means it's easy for USCIS to data mine and see when one person has submitted multiple registrations. Then they're going to go looking into those companies. And a lot of times what we see is they select those, they approve them, and then a year later, 2 years later, they go back and revoke them because they were actually fraudulent filings. These companies that are advertising telling you to file multiple petitions and we'll file for you even though we don't have a project, we'll have in-house projects, or we'll find a project for you later once you're selected. You have to be very careful of those because they could ultimately lead you to getting a revoked H1B for fraud. And once fraud is involved, there are very little options to come back from that. There are very few waivers. It's not an easy process. Most people don't qualify for it. So our recommendation is stay away from that. Do not do it.
I will tell you some of the example where people have fallen down to these kind of scams, guys. There's a company called Integra Solutions, Aztec Solution, Unveil, and Wireclass. Approximately around 7,000 F1 students fell into the trap. They're all in trouble because of the fraudulent employer giving fraudulent letters. They are in a big, huge trouble. They're getting deported, they're getting thrown out of the country, they're getting arrested. So these are the things that will happen if you go with the fraud companies. The second thing that we do is that, especially the Trump administration, they didn't used to weed these fraud companies. They used to approve them very easily and then come and revoke their H1Bs. And guess what? They don't come to Facebook and post the messages saying that my visa got revoked. We tell those things to you guys. You don't believe it. Believe me, there are approximately around 20 employers who are being criminally prosecuted every year that we know about. We get consulted about. Of course, there are a lot more that we don't know about. And these are the things that don't fall into the pitfall, don't fall into these things, don't fall into the trap. Questions that are coming up is that my lawyer filed adjustment of status in a wrong category for the dependent, but it was receipted. How do I correct it? Easy. It's an easy. You got receipted, you don't have a problem. It's called interfiling. You do interfiling, you tell them there is a clerical error in filing the application. This is the proper filing. They will take it, will not penalize, will not have any problem. You'll be fine.
Mano from Facebook wants to know, why is there no piecemeal immigration bill for high-skilled or employment-based until now? We had Senate Bill 386 and HR 1044 last year. These have not been introduced in the current Congress. I've not heard any news or rumors about the Fairness for High-Skilled Immigrants Act being introduced in the near future. I think that a lot of people are kind of waiting to see what happens with Biden's immigration plan. And also we have so many different immigration bills that are coming forward, maybe they'll be able to add it into those. But I do think it's something that you should continue to push for. Contact Representative Zoe Lofgren's office and ask her to reintroduce that Fairness for High-Skilled Immigrants Act, because we do need to have that passed. And if it's introduced into Congress, and we had so many different co-sponsors that got so close past the Senate last year in a different form, I think we can do it again, and possibly as part of some of this comprehensive reform. But if all of that falls down, at least this can move forward in the piecemeal fashion.
Good question came out from Meera Sahib Sheikh. Do you recommend doing premium processing if my kid is getting aged out soon? No, I do not recommend premium processing. At the same time, I want to warn you that when the final action date becomes current, though, I want you to do premium processing, because the only way that your son age gets freeze is that your I-140 should be approved. If the I-140 is not approved, your kid age does not get freeze. So you need to be very alert, and as soon as the final action date becomes current, file the premium processing. There was one person who was on the TV show, Emily, and she was telling that her final action date become current, and she's sending these things, she's getting the rejection of the premium processing. You know what I told her to do? I told her to file multiple premium processings. I mean, file a premium processing, wait for 2 days, file a premium processing, file a premium processing. One day they'll get it and they'll accept it. And all we need is that one premium processing to save the kid to get the I-140 approval. And it's not. Now, Emily has said duplicate filings is wrong. That is applicable because you're trying to defraud even if you don't have a job. Here, since the USCIS is not acting it, there is nothing wrong in filing multiple premium processing for the same application. Nothing wrong in it. You can do it to protect your kid, nothing wrong with it.
Rajesh from Facebook wants to know, if we use the green card EAD and we're in the 7th year of H1B, and if for some reason we want to switch back to the H1B, do we have to go through the lottery again? No, you don't. what you do have to do is consular process that H1B, and you have to make sure you have a valid advance parole so that you don't abandon your pending green card application. But once you've been counted in the cap, even if you're beyond the 6-year limit and you have that approved I-140, you are not subject to the cap again.
Question from AD. His I-140 is approved, priority date is December 2015. With the previous employer, got an offer to join, with the current employer, got an offer to join, I have an I-140 approved with the previous employer, got an offer to join the same employer with a higher salary. If accepted, your filing J supplement is enough or eligible to file the adjustment of status in October 2021. If the priority date becomes current, you're going and joining the company that has already I-140 approval. Then that company can file the 485J supplement and you can file the 485. Absolutely no problem for it. If by any chance the previous company that you're going and joining that has I-140 approval has withdrawn the I-140 approval after you left the company, they have to refile the I-140. They have to refile the I-140 and they can file the 485J supplement when the I-140 is pending, but they most probably don't have to file a PERM application. So if they have not withdrawn it, all they need to do is that file 485J supplement. You can join the old company.
Zahid from Facebook had an H4 extension denied because the biometrics appointment was missed, but never received it in the mail. We do see this from time to time. I actually handled a very similar case earlier this year. We were able to file a motion to reopen, and we provided proof that the individual never received the biometrics notice and that the attorney never received the biometrics notice. They did reopen that case and scheduled them for biometrics so that they could attend and get the H4 approved. So that is one option. Another option, if your current H4 has not expired, is just to refile the application. If your current H4 has expired, then you should talk to a lawyer to understand whether it's safer to file the motion to reopen or to exit and apply for the H4 at the consulate.
Jignesh has this question, and Emily, I'm being quizzed with the kind of biometrics that they're issuing. In some biometrics, they are telling it's only 765, some biometrics they are telling 485, some biometrics they are telling 485 and 765. Technically speaking of, biometrics are only required for 485, not the 765. What's going on? I don't know. I have no clue.
USCIS knows what it's doing.
We have no clue, and we have all kinds of things going on. They are trying to expedite as much as possible. That's all we can see, but all kinds of things are going on. For you guys, you get the biometrics, you do only one thing, you go for biometrics. If you get 2 biometrics, you go 2 times. If you get 3 biometrics, which I've seen it, go 3 times. No questions asked, take it. Don't try to think that, oh, I got biometrics on March 25th, I got biometrics on April 2nd, I'm not going to go for April 2nd. Don't do that. Go for both. I don't know why they're issuing, it's just very confusing how they are issuing. I got a question here with regards to the, do you think so that, the question is that, do you think so that the administration is going to waive the interview process completely for the employment-based adjustment of status? Emily, I believe at this point of time, unofficially, there's no interview process for employment-based.
Yeah, I agree. Now, is that a COVID thing or is that an administration thing?
We don't know.
Sure,
We're not sure.
I mean, Mayorkas was there in the administration when we didn't interview, and so I'm sure he sees the interview as a big stumbling block for people to get the approvals processed on time. So I have a feeling that that is likely to happen.
So most probably, unofficially right now, there is no interview process for the adjustment of status. That's the way we feel it, and we're going to update you next week what's going on. But in the past 1.5 to 2 months, I haven't seen any 485 interviews at all, but I do see the 485 approvals without interviews. So unofficially at this point of time, no interviews, guys. That's a good news. We'll update you if anything comes up as we go on.
And we have been seeing family-based interviews.
Yeah, of
so
course.
that
We
tells
have,
you
oh
that
yeah, we have seen family-based interviews.
it's not
coming.
that they're not interviewing at all.
No, they
because
are
of COVID.
interviewing. They are interviewing, but they're not interviewing the employment-based immigration. For sure, I can say that if there is any criminal history, or if there is anything odd, they are going to interview for sure. Even if some of the small criminal things might not have a negative impact in getting the green card or not, once they see the arrest record, they are going to interview. That's for sure, has been historically there.
Sonali from Facebook had an issue with the 485 being rejected as not properly filed and wants to know, how can I resubmit now that the priority date is not current and I'm in EB2? Really depends on the reason that they say it was not properly filed. If it truly was properly filed, then you resubmit it and explain that it was rejected in error and USCIS should accept it. We are seeing that they're starting to accept some of those. We've refiled a number of them and we're waiting to see if they've accepted them. If it truly was filed incorrectly, you may have to wait until the final action date becomes current, or October, the filing date should push forward again and you probably will have an opportunity to again. So hopefully you are continuing to maintain your non-immigrant status and hopefully you'll have the opportunity to fix it in October if they won't accept the refiling now.
Shastri Kunduru from YouTube has this question. He has his H1B approved, stamped, done in India with company A. Now it's been acquired by company B. He got H1B approval with company B. Is he eligible for Dropbox? Yes, you are. If your passport visa is expiring for less than 4 years, you are eligible for the Dropbox. Absolutely you are. There is no requirement that the previous H1B must be for the same company. When the Dropbox was being started back in olden days, they put a restriction that when you go for the Dropbox, the previous H1B has to be with the same company. They have taken it away now. It doesn't have to be with the same company. It can be a different company. And let me tell you some of the good news. The rule was that if the passport visa must have been expired by less than 1 year was the rule. Now they changed to 2 years. That means that even if the passport visa expires by 1 year and 11 months, you can still apply for the visa stamping. Guess what? Now they come back, the Biden administration comes back and it's 4 years. So if your passport visa has expired and you're going there for stamping in the similar category, that means if you're going for H1, you're going again for H1, within 4 years, that means if 3 years and 11 months, you can still go for stamping. It can be for a different company, absolutely not a problem. One of the other requirement is that your previous stamping must have been from your home country, from your India. That's a requirement though. If you got it from Mexico or Canada, you cannot go to Dropbox in India. That's one of the requirement.
Priyanka from Facebook wants to know, to avoid biometrics, can we travel to India if eligible for Dropbox? That is a possibility. That's something that prior to COVID, we were seeing a lot of clients doing. Instead of filing their I-539 with USCIS, they would file the H1B or the L1 extension in premium processing, get that approved in 2 weeks, and then the spouse would exit, get the H4 or L2 stamped at the consulate, and come back and then file the EAD renewal at that point. And that did seem to speed up the EAD processing time because you were no longer dependent on this biometric delay. Now, right now, obviously we have some travel issues. Visa processing is not as smooth and easy as it normally is, but if you're eligible for the Dropbox, that is an option that you may want to consider.
V. Lakshmi has filed EB2 and EB3, both of them, one on the final action date, and now there is final action date has become current. What is the right time to withdraw one adjustment of status? I don't see any reason to withdraw the adjustment of status. I'll wait. If the final action date gets approved, I'm going to take it. If not, who knows? Maybe the other lane moves. So I would not withdraw until the USCIS requests you to withdraw one of the 485 application. That's my judgment call, but if your lawyer says otherwise, I'm not going to disagree with that lawyer. This is just my judgment call.
Vinita wants to know, what are the difficulties we've come across filing downgrades for physical therapists? Well, so far I can tell you we have not come across any difficulties. We were concerned whether we could get USCIS even to accept it because there was no current prevailing wage determination. We were using an old labor certification and an old prevailing wage, old notice of filing when we did that. And luckily, in the cases that we were able to file in October, we did get them to accept it. We got receipt notices. Now the I-140 is pending, and we're waiting to see if USCIS will approve them or if they're going to issue some kind of RFE regarding the prevailing wage being expired or the notice of filing being done more than 180 days before the downgrade was filed.
Sandeep Reddy has this question. While the AOS is pending, can we travel outside with the H1B stamping and come back into the United States? Will the AOS will be denied? No, AOS will not be denied. You can use the H1B stamping to come back into the United States. Your spouse can use H4. But one thing I want to be careful is the advance parole that you have applied, you should consider that it's denied. Even if they approve it, do not use it. I want you to refile the advance parole application. That's also called as I-131. Even though you get an EAD and advance parole card in one card, I still do not want to use your advance parole for any purposes if it's approved while you're outside the country.
Sunil wants to know, how do we know if an employer has revoked an I-140 petition? Well, first, the employer doesn't have the power to revoke an I-140. Only USCIS can do that. Now, the employer can send notice to USCIS to withdraw an approved I-140, but if it's been approved for at least 180 days, USCIS won't revoke it. It's simply withdrawn, but it's still valid for you to use it for H1B extensions and for the H4 EAD and for you to retain the priority date. But how do you know if it's actually been revoked or withdrawn? You can check the case status online using your receipt number. A lot of times it does update when they've sent a notice of revocation or a notice of withdrawal. If that does not show online, the only other way is to ask your employer, which we generally don't recommend because that may trigger them to go ahead and withdraw it, or to do a Freedom of Information Act request or FOIA request. You can do that. Go to USCIS. Google USCIS FOIA. You can fill it out online. It takes a couple of weeks to get it, but you should receive the I-140 file and you can see whether it is approved or revoked.
Biswas from YouTube has this question. My prior date is 2013, January. Can I now, I-140 is approved. Can I now file a 485 application? I'm in EB3. If you have not filed an application in October, November, and December, and January of 2010 and 2020 and 2000. Now the prior date has backlogged. They're not going to accept the filing dates. You need to understand the difference between filing dates and final action dates. The filing dates are current for you, but the USCIS does not allow all the time to file. They only allow sometimes to file the filing dates. Out of the past 60 months, approximately around 12 or 14 months out of the 60 months, they have allowed the filing dates. Every time they issue the visa bulletin, which normally is issued between 10th and 20th, and sometimes they may take up to 27th also, the next month, that means in the month of March, you will be getting the April. So you need to look into the visa bulletin from the State Department. In there will be a link to the USCIS. You need to go to that link and then find out if in that particular month, that means in the month of April, they will tell in March, in the month of April, would they accept the final action dates or filing date? Based on that, then you can then go and file the adjustment of status. Right now, on January of 2013, the final action dates are not current for you. USCIS is not accepting the filing dates, so you cannot file the adjustment of status right now.
Jagannath wants to know if there's any possibility of the filing dates getting moved before October of 2021.
Yes.
So, we've had these filing dates for 5 years now.
Oh, did you say filing dates? Sorry.
Filing dates,
okay.
yes.
Sorry.
The filing dates generally move in October only, and then sometimes in the summer. Now, what causes a filing date to actually move forward? That only happens when the Department of State has more green cards available than applications pending that are ready to be approved. Given last October and how many people filed, I don't expect that to happen. I don't see USCIS going through all of the applications they received and still having green cards left over to where they need to move those filing dates to generate more applications so that they can use up all the green cards. I would expect only in October will the filing dates move forward.
GK has this question. My previous employer has filed a 485 application. Is there any problem if I transfer it to after 180 days to the current employer using the 485J supplement? You can do so, but make sure that your underlying I-140 has been approved. If the underlying I-140 is approved, yes, you can file the 485J supplement. Another confirmation people are asking, Suresh B is asking, is the green card interview waived for all employment-based application? Now, in the past 1.5 months, we are seeing a trend that there are no interviews for the employment-based. If anybody thinks so, they got an interview, they can post a message so that me, Emily, and everybody else also get it. This is the information, and we are seeing that the family cases are getting interviewed. So unofficially, we see that there are no interviews conducted. But is it official? Can you trust this one? No. They didn't release any information officially that there are no interviews. It is a trend that we are noticing. That's the reason why you guys need to get educated every week, because immigration is a moving target. It doesn't stay like the still. I mean, every week, every month, things changing, and that's the reason we conduct every week this YouTube and Facebook to educate you. Now, this can change. This has changed in the past 2 months. It may change, but we will update you if there is any change.
Sivakati wants to know, my wife's H4 and EAD are pending, and if we want to move to another state or a different address, what do we need to do? So first thing, you can fill out an address change form online at uscis.gov, and when you do the online version, it will ask you, do you have applications pending? You'll need to enter in the receipt number for both the H4 and the EAD, and USCIS will update the address on those applications. I would also recommend a few days later calling USCIS, the 1-800 customer service number, to verify that they have the new address on record for the EAD and the H4, because a lot of times we see that people update their address with USCIS and then they send the approved EAD to the old address, and then it gets returned back to USCIS, and then it takes months to get it reissued again. Sometimes they just destroy them and you have to go through the whole process again. It is quite a problem. Now, if you were getting ready to file and you knew you were moving, I would say have your attorney list their address as the address that they want the EAD mailed to, so you don't have to worry about that. But in your case, it's already done. So make sure, do the online address change and then call to follow up. Call even another time. Just make sure that they have your correct address for the EAD.
And did you mention about the AR11, Emily?
No, I did not specify the AR11.
Yes, you need to file, when you're changing the address change, you need to file AR11. And make sure that you file AR11 for 2 things. One is H4 and also EAD separately. When you fill the AR11, you go to, just Google it out, USCIS AR11. That's a very proper way of changing the address too. Questions that are coming up is, my daughter's H4 is expiring in December 2021. I'm assuming that it's because of she's aging out. She's becoming 21 on December. Adjustment of status has been filed on October 20th. Do we need to file for F1 for now? Mr. Venkata, if the final action date is not current, which I'm estimating it is not current, if your daughter is turning 21 in December of 2021, you need to file for her F1 visa because you don't want to gamble on it. Now, if the final action date becomes current and she is saved by the CESPA, the State Child Service Protective Act, at that point of time, you can withdraw the F1 application. I know that you don't care about the little money that you're going to pay for the I-539 to file the I know that you're not that concerned about it. So it is in your best interest that if the final action dates have not become and she is turning 21, you need to file F1 visa right now. There may be some hiccups. You may discuss with a lawyer on what are the pitfalls that may pop up. But at this point of time, the best path for you is not take a risk, even though the State Department has made some statement, even though Emily has made some statement, even though Rahul has made some statement. The fact of the matter is, at this point of time, the final action dates are not current. Your daughter is not protected by it. So you still need to take it until the things will come, until the final action date becomes current and your I-140 is approved. So please take the corrective action. And when the dates becomes final action date become current, yeah, then it's a totally different issue. And you also need to watch our video, Aging Out Children of 21, that we put it about 3 weeks ago. Emily and I did presented a very good thing. I want you to watch it. I want your daughter to watch it and take the precautionary methods well in advance.
Dripto from Facebook has a STEM OPT EAD that's valid to June, planning to file the H1B petition before June, but wants to know if once the H1B is filed, can you travel and then re-enter before the OPT expires? That is actually going to be a problem because the only way that you qualify for the cap gap, the automatic cap gap that extends your OPT EAD from June through September 30th, is if your H1B requests a change of status. So when you file your H1B and request a change of status, and then you travel while it's pending, your change of status automatically gets abandoned. Your H1B is going to be approved for consular processing. You will lose the cap gap extension of your OPT. So you need to make sure that you plan the timing of the filing of the H1B and your travel very carefully so that you qualify for that cap gap extension.
BJ Patel from YouTube has this question. I have a previous priority date of May 2013 with company A. Currently, I'm working for company B on a H4 EAD, and the company B doesn't want to file for a green card application. Can a third company, company C, even though I'm not on H1B, I'm working for company B, can the company C file a green card application for me even though I'm not working for the company? Yes, they can. Absolutely, it's legal to file even if you're not working for the company. And the good part is that you said is that you're a physical therapist. Physical therapists do not require labor certification. I mean, they don't have to go through the entire labor certification process. It's a quicker process compared to the labor certification. You don't have to file with it. You already know that you've got the previous labor and I-140 approved previously in 2013. So yes, it's very good. I don't know why you missed the boat in October of 2013, but you can still try it right now. You should be able to file it right now. Don't wait until the priority date becomes current again. I want you to take an action. The company C can file the green card application for you immediately. Luckily, you have a lot of exemptions available, the steps needed for the labor certification.
Sen wants to know, while keeping my job with my primary employer, can I join a second full-time job? Should I be worried about moonlighting? It depends on your status. So let's say, for example, you are in H1B status. You can join a second job in H1B status, but the second employer has to file an H1B petition for concurrent employment to allow you to work for 2 employers at the same time. And that second petition has to meet all the same H1B requirements, has to be a specialty occupation and all of that. Let's say you're in L1 status, then no, it's not an option because your L1 only authorizes you to work for the L1 employer based on that intra-company relationship. What if you are have your green card pending and have an EAD? Then that may be an option because the EAD does allow you to work for any employer, but you need to make sure that if you do that, you're going to be married to the adjustment of status because using that EAD to work for the second employer means you're no longer maintaining your H1B status, for example. So in some circumstances, that is possible.
Anything else, Em?
I think we about are out of time for today. Thank you for joining us. Just as a reminder, we do have our daily conference call that is now on Zoom. So if you go to rnlawgroup.com, you can get the details and schedule for that. And you can also subscribe to our newsletter there at rnlawgroup.com.
Thank you very much.